Clause 25 is about the determinations of the contractor's employment by the employer. For full statement, you may refer to the PAM contract 2018. There are 8 sub-clauses here. The relevant information will be briefly discussed based on the slides given here. This clause is about the determinations of the contractor's employment by the employer. That means the employer determines whether to terminate the service given by the contractor, remove the contractors from the contract. This normally happens when the contractor is default. The meaning of default here is failure to fulfill the obligations. That means something wrong with the contractor and the employer cannot work with the contractor. In order to prevent the damage, the employer can decide to remove the contractors from the project. Now let us talk about the defaults by contractor. A contractor is considered default if any of these happens. First, without reasonable cause, fail to commence the work as per the contract. That means the contractor is unable to carry out the work in accordance to the contract without any reasonable reason. Second, without reasonable cause, the contractor suspend the work before completions. That means the contractor stop working before completions without any reasonable reasons. Or the contractor fails to proceed regularly and or diligently with the work. Regularly means that the contractor is not continuously carrying out the work, sometimes working, sometimes not working. Or diligently is related to the effort put into the work. A contractor can also default if he consistently refuses to comply with an architecture instruction. That means he don't want to follow the instructions of the architect. You know that based on clause number 2, the contractor is required to comply with all the architect instructions. If the contractor do not comply, the architect will need to issue a notice requesting the contractor to comply. And if the contractor chooses not to comply again, this constitutes a default. Also, if the contractor fails to comply with clause 17, he is also considered default. Clause 17 is about assigning other parties without the employer consent and not to subcontract the work. If the contractor subcontract the work, he is considered default. The definitions of subcontracted work means that the contractor wholly or substantially subcontract the work to somebody else. This does not include subcontract the laborers to carry out the work. That means the contractor can still subcontract the laborers to carry out the work, but not actually subcontracting the contract to somebody else. Another way that the contractor can be considered default, it will be when the contractor abandons the work. What you see the list that constitute default, they have something in common. All of these are not allowed in the contract. It is related to the contractor either reluctant or not able to fulfill the obligations. So when this happens, the employers have the right to terminate the contractor. Now we talk about the procedures of determinations. When the employer decided to determine the contractor's employment, the employer will need to give the first written notice to the contractor. This may also be issued by the architect on behalf of the employer. The purpose of this written notice is to document the process, which at the same time serve as a warning to the contractor. If the contractor still persists with the default, the determinations will happen. The durations given, it will be 14 days. If the contractor still default for the 14 days, the second written notice may be given. This second written notice can be given within 10 days before the expiry of 14 days. Within these 14 days, if the contractor still remains default, the second notice may be issued. The second notice cannot be issued immediately the second day after issuing the first written notice. At least a few days buffer should be given in order to observe the response of the contractor. But the limit, it will be 14 days. The PAM contract requires this written notice not to be given unreasonably, as determinations of the contractor's employment is a serious matter. It is likely enough to be disputed. Therefore, you will need to confirm whether the contractor is default and follow the proper procedures to trigger the determinations of the contractor's employment. After that, the employment of the contractor determined. That means the contractor can now be terminated from this project. Now, both of these written notice will need to be delivered by hand or by registered post. Make sure that the contractor is well unknown of his status, and the default by the contractor should be clearly specified. Make known to the contractor what caused this determination process. Now, in the case that the contractor's insolvency, that means the contractors undergo bankruptcy, the employment of the contractor shall automatically be terminated. Next, when the employment of the contractor is determined, there are duties and rights of the contractors and the employer. The contractor will need to return the possessions of the site to the employer. With that, the contractor will need to vacate and return possessions of the site to the employer. Next, transfer the benefits of agreement. The purpose here is for the continual of hiring the construction plants and the equipment which is already on site. And it is also for the supply of materials and goods. This will allow smooth transitions from a contractor to another contractor who is continuing the works. Whichever thing supposed to be on site will remain on site. Next, it will be the removal of the belongings of the contractor. This happens when it is instructed by the architect to remove the temporary buildings, construction plants, tools, equipment, materials and goods belongs to or hired by the contractor. In order to remove all this, there should be a written instructions by the architect. It is to prevent that the items that are not supposed to be removed being removed by the contractor without any consent. Only those stated in the notice here is allowed to remove. And the removal of the belongings has to be done within the reasonable time. Normally, it is stated in the written notice by the architect. If the contractor still not complying, the employer may remove and sell those property without liability. Next is about the cost incurred. The contractor is to pay the employer all the costs to complete the work, plus all the losses and expenses suffered by the employer. The work supposedly done by the contractor, now only done halfway. If the contractor abandons the work, there will be loss suffered by the employer. and all the relevant costs should be paid by the contractor. With that, before the completion of the work, no payment by the employers to the contractor should be given. This includes those certified but pending payment. That means by the time the contractor is determining the employment, all the payment should be on hold. There won't be any further payment. Even those certified but not yet paid shall also be on hold. Everything will have to wait until the completion of work, so that the relevant costs incurred due to the determinations of the contractor's employment can be confirmed. Then the employer and the contractor will resolve the monetary issues. After completion of the work, all the costs incurred are to be concluded in the final account. The final account is the document showing the adjustment of the contract sum. For more detail, you may refer to clause 30.10. Now that the contractor's employment has been determined by the employer, there is another important process here to assess the status of the work, as well as to confirm the belongings, which should go to who. With that, the architect or the quantity surveyor, within 28 days of the determinations of the contractor's employment, give a written notice to the contractor for the date of inspection. These inspections, it will be a joint inspections between the contractors and the architect and quantity surveyors. They will need to appear together and carry out a jointly record regarding the extent of the work executed, as well as the materials and goods delivered to the site. This process is important for the purposes of the final account and to resolve the monetary issues between the contractors and the employer. The contractor will need to be attending this inspection. First is to give clarifications in terms of the work progress in case of any inquiry by the architect and quantity surveyor, so that the outcome of these inspections will also be fair to the contractor. The contractor should be paid for whatever works that he has executed, as well as the materials and goods which has already been delivered to the site. The pending works shall be considered non-completions by the contractor. Next is about the final account. When the determinations of the contractor's employments happen, this final account will only happen after the completions of the work. This was in line with the principles here. Before the completions of the work, no payment should be given to the contractor. It is so that when everything is completed, the total cost incurred can be calculated. So this final account, it will be within 6 months on the completions of the work. The architect or quantity surveyor will submit to the employer and the contractors for their agreement. This final account should include the sum certified to the contractor before the date of determinations, the liquidated damages incurred onto the contractor, the amount set off by the employer, and all other losses or expenses suffered by the employer due to the determinations of the contractor's employment. These final accounts are sent to both the employers and the contractor. They will need to review the amount if there is any dispute between the employer and the contractor. There are two possible outcomes here. The first one is without dispute. The second one is with dispute. Without dispute means that both the employer and the contractor agree with the final account, And with dispute here means that either the employer or the contractors is not satisfied with the final account. As a result of whether there is dispute, the following actions differs. Now let us look at the case when there is no dispute. Now both the employer and the contractors are agreed with the final account. Within 3 months of the dates of the receipt of the final account, the final account is considered conclusive. If there is any disagreement between the employer and the contractor, the disputing parties will have to arise the dispute, and if both sides are silent, then the final account is considered conclusive. If they deem that both parties are agreeing the final account. Now that the final account has been confirmed, there are 2 possible outcomes. It is either the final account is greater than payable by the contract, or the final account is less than the total payable by the contract. The amount payable by the contract, it will be determined by the extent of the work done by the contractor up to the date of determinations. The contractor should be paid for the amount equals to the amount of the work done by the contractor. Now let's say the final account here is greater than total payable by the contract. That means the contractor is being paid more than he's supposed to be. The employer will need to salvage the cost. There are 2 ways to do so. First is the contractor pay to the employer. Second, it will be the employer recover the sum from the performance bond. Either will do. This is to protect the right of the employer, getting the amount that the employer is supposed to have. This is possible because the final account also includes the liquidated damage as well as the losses or expenses suffered due to the determinations of the contractor's employment. This is going to result in additional costs to the employer, and when this amount incurred, it offsets the amount that has already paid to the contractor, then the contractor will need to pay back to the employer. Now the second case is the final account is less than the total payable by contract. That means even you have incorporated the liquidated damage as well as the loss and expenses suffered due to the determinations of the contractor employment, the employer still owes money to the contractor. In this case, the employer will need to pay to the contractor. Eventually, the contractor should get the portions that he deserves to have. The PAM contract has made it quite clear to protect the interests of both parties in a fair and just manner. Now, let's say within these 3 months, any one of these parties here disagree with the final account. That means there will be dispute in terms of the final account. Within the 3 months of the dates of receipt of the final account, the disputing parties will need to write notice to another party raising the dispute. The relevant particular will need to be enclosed to prove the dispute, and this notice will need to have a copy to the architect and the quantity surveyor. It is so that the contract administrator are aware of this in order to trigger this dispute process. Now, within 3 months of the date of the receipt of the ground of the dispute, the architect or the quantity surveyor will need to study the case and decide whether to amend or not to amend the final account. This is based on the eligibility of the contractors or the employer to claim for those amount. Theoretically, this should be the final decisions that confirm the final account, and this should be made known to the contractors and the employer. If either of these parties still not satisfied, then this case should be referred to the arbitrations in clause 34. This should be done within 3 months from the date of the decisions. If no arbitrations process is being triggered by any of the party, then the final account after considering to amend will be deemed conclusive and agreed by both parties. Next, we talk about the remedy limited to damage only. Now we are in the state that the contractors is being determined by the employer for the employment. With that, the contractor shall yield possessions of the site within 14 days. That means the contractors will need to prepare to vacate the site, remove the belongings, and give possession back to the employer within 14 days. He will need to remove his personnel and labor force, but not the construction plants, tools, equipment, unless it is instructed by the architect. Remember that previously we mentioned about the notice regarding the determinations of the contractor. It shall not be given unreasonably. If the notice is given unreasonably, it will be not valid. However, based on this clause here, once the contractor receives the written notice to determine the employment, it will be irrespective to the validity of the notice. The validity of the notice shall settle later. Regardless whether the notice is valid, the contractor shall remedy and limited to the compensations for the damage only.